citizens consist of Alpha Phi Alpha, Alpha Kappa Alpha, Kappa Alpha Psi, Omega Psi Phi, Delta Sigma Theta, Phi Beta Sigma, Zeta Phi Beta, Sigma Gamma Rho, and Iota Phi Theta. The council in Chicago is one of the largest councils in the country. We have representatives of 65 chapters in the Chicagoland and Gary, Indiana areas. NPHC's core mission is service. We were very instrumental during the COVID pandemic. We were giving away food at food pantries. We also helped with the voter registration drive. Our main focus and mission is social injustice, education reform, Black health, and supporting Black businesses. And we are so excited to be partnerships with the Illinois Judicial Council to bring these judicial awarenesses. But most important, we bring you judges who look like us. Now, this is our third week of these panels. If you missed the last two, the first one was on evictions, foreclosures, and bankruptcy. And last week we did domestic relations and domestic violence. Tonight is child protection and juvenile justice. Just a few house rules. The judges presented will not provide legal advice. They only give you general information. You should contact an attorney to obtain advice on any subject matter. Thank you, and I hope the information you hear during the next week will be helpful. I'd like to introduce Illinois Judicial Council President, the Honorable Judge Bonita Coleman.
Good evening and welcome to our program, Judges in the Community. I am Judge Bonita Coleman, President of the Illinois Judicial Council. And before we begin our presentation, as I have began in the last couple of presentations, that was to thank Mr. Malcolm Whiteside Jr. and the National Pan-Hellenic Council of Chicago for assisting us in bringing this presentation to you. The Illinois Judicial Council is an association of predominantly African-American judges. Our judges are on every level. We have judges on the federal level, state, and administrative law judges. Our theme this year is to strengthen our foundation to empower and uplift our community. Each and every one of the attendees here tonight at some point has had a legal problem. If it's simply challenging a traffic ticket, appearing before a court to answer a criminal charge, get a divorce, do a bankruptcy, at some point we have had some type of legal issue that we needed information about. If you haven't, I'm sure you knew someone who has. Knowledge is power. Our goal with these presentations is to provide you with information about legal resources in the community that will empower you when you are faced with a legal challenge. Each one of our presenting judges this evening has presided over the cases that they will speak about. Presided over the area of law that they will speak about. Tonight's presenters will speak about child protection and juvenile justice, as you have already heard. And on next week, we will bring you information about legal resources regarding traffic, pretrial, and criminal law. The next voice you will hear will be our moderator, Judge Cherie Henry. She will provide you with a short overview of the court process. Thank you and enjoy the presentation.
So before we get started, I want to talk about Zoom etiquette. As you know, the Illinois Supreme Court wants everyone to have access to justice. And through that, we use Zoom. But when we come to court through Zoom, there are certain expectations that we as judges have for you. And I just want to go over a few of those. So no one should miss court because of Zoom. Whether you are at work, whether you are at an appointment, whether you're in your car. If you're in your car, you can pull over and Zoom. Zoom gives you access to your criminal justice system, your justice system in general. So when you come to Zoom, court through Zoom, there are appropriate locations in which you should Zoom from. That would be your living room, your dining room, and your kitchen. Do not Zoom from your bedroom. Do not lay in the bed while you're Zooming. In addition, if you miss your court date, you can still Zoom in the next day and try and find out what you need to do to rectify the fact that you missed your court date. You can also call the Cook County Clerk's office and find out. When you Zoom, when you come to court through Zoom, you should remain on mute until your name is called. If you have a question, you can raise your hand through the Zoom question, or you can put your question in the chat. Zoom is there for everybody to use so that they can appear in court and that they can see how our justice system works. Now, I want to introduce our wonderful panelists who have tons of information to give you so that you can be prepared or a loved one can be prepared. We hope that you will give this information. We hope that you will share this information with any and everyone if you discover that they need this. We are your judges in the community, and we want you to know what's happening in and out of the justice system. So the first panelist we have is Judge Andrea Buford. She is in child protection, and she will start by introducing herself, telling us a little bit about herself, and then she will also explain what happens how a case gets to her and what happens when it gets to her and how long it generally lasts in her courtroom. Judge Buford, the floor is yours.
Thank you, Judge Henry, Judge Coleman, and Mr. Whiteside. Thank you. My name is Andrea Buford. I'm a judge. I sit in the Child Protection Division. I'm a product of the South Side of Chicago, very proud product of the South Side of Chicago. Holy Cross Elementary School, Aquinas Dominican High School, Northwestern University, and IIT Chicago Kent of Law. So I'm very familiar with the city and what goes on here. I'm also a past president of this wonderful organization, the Illinois Judicial Council. I'm also a past president of the Cook County Bar Association, which is the association of predominantly Black lawyers and judges. I've entitled my presentation, What to Do If the Department of Children and Family Services Comes Knocking on Your Door. The first thing you should know that it is our job, it is our duty to resolve matters by doing what is in the best interest of the child and to keep the family intact when we can. In most instances, a call or someone will call the department's hotline regarding a potential abuse or neglect allegation. An investigator will then be assigned by the department to investigate the matter. It's possible that the complaint will be unfounded and that will be the end of the matter and it's closed. However, if the investigator determines that there could be abuse or neglect in the family, they should offer the family some type of intact services or some type of services prior to coming to court. They will offer services like therapy, maybe domestic violence if it's needed, maybe even housekeeping services, or they could enter into a safety plan with the family and place your children with a close friend or relative while they work with you in correcting the conditions. You should know that the services at this point are voluntary. However, if you do not cooperate, if you do not complete those services, the next step is for the department to come into court to see a judge within 48 hours by filing a petition and alleging abuse and or neglect allegations against the family. If your children are removed by the department, again, they have to come into court to see a judge. The judge will decide if probable cause and urgent and immediate necessity exists to support the removal of the children. At this point, we will appoint an attorney to represent you in the matter. We will verify the names in the petition that the department has filed and the addresses. This is where it can get a little sticky because we have to be able to identify fathers. We can't proceed without identifying the father. So the judge or the state who's verifying the petition will ask you who, if the father isn't there in court, will ask you the name of the father. If you don't really know if there could be more than one person, please give us all the names. We have to be able to identify and serve the father. He has a right to know, and we have to give him notice of the court. So please, it's important that you provide all potential names of fathers to the court. The parent can then request a hearing, or as most often happens, the parties will agree to the allegations in the petition. For instance, the court may look at the petition and make a finding that urgent and immediate necessity does exist to support removal of the child from the home. It could be that the mother and the child tested positive for illegal substances at birth. It could be that the mother admits to using illegal drugs. It could be that the family is undomiciled. Of course, we can't just remove a child from a home because the family is poor, they're living in poverty. There has to be something else to it. Another example is when the parents have been involved in a domestic dispute and maybe the mother was holding the baby and the father or the mother hits one of the parent, hits the other parent, and the baby is hurt in the process. And the family has a history of involvement with the police. And another example, the minor may have observed the parent slurring words. Parent is unable to stand. They saw the parent drinking alcohol from a bottle, and the minor has many unexplained absences from school, and the child says that he's unable to attend school because his mother or his father, that they're drinking all day. We should also find that reasonable efforts cannot prevent or eliminate the need for removal of the child from the home. In other words, we'll ask if the department attempted to provide some services to the family so that we do not have to remove the children from the home. Then we will then appoint, if the state did use reasonable efforts, we will appoint a guardian, a temporary guardian for the children. The state becomes the temporary guardian of the children, and the children are removed from the home. Now we prefer to place the children with a family member if possible. So the assigned worker will ask you to identify any family members you have that we could place those children with while we take care of the issues in the home. The department will have to investigate the family members and make sure that their homes are safe and appropriate for the children to stay. Again, we will address the issue of paternity and visitation at that point. If the parents were not married, we will order a paternity test at no cost to the party. We will also enter into a visitation schedule. If the case involves a newborn baby and maybe the mother is breastfeeding, most judges will order a liberal visitation so that you can continue to bond with the baby. The judge can also or should also order mediation. We have a mediation service. We'll call a mediator in, and the mediator will sit with the family, with the department, and with attorneys and work out any kind of issues you might have, like visitation. You might have issues with whoever the foster parents are. You may need help with transportation to visit the baby, to visit your children, or to get to your services. That is the end of your first appearance in court. It's called a temporary custody hearing. We take temporary custody of the children. Before you leave the court, the judge should explain to you your rights. You have a right to be in court at all times. You have a right to counsel. You have a right to be present at all court appearances. You have a right to be heard. You have a right to cross-examine witnesses and the right to examine pertinent court files and records. We will strongly advise you that you must cooperate with the department. I make it my personal business to look a parent in the eye and say, we don't want to keep your children. It's not a good thing to have them as in the system. So if you would only cooperate with the department, if you complete the services that they require of you, we can return your children to you. If you cooperate and do what you're supposed to do, I'm your best friend. I want you to have your children back. If you don't, I don't want your children staying in this system for a long time, and you will risk having your parental rights terminated. it's almost like a blueprint. You will sit down with the worker assigned to your case, and they will identify services you need. Usually they identify therapy, individual therapy. They will identify domestic violence if it's needed. They might identify some type of substance abuse treatment if it's needed, including random urine drops. There are a lot of services that the departments will suggest for you. Shortly thereafter, you will meet with the worker assigned to your case, and that worker will complete or prepare what is known as a service plan. The service plan has every service in it that you have to do. As I said, it's like a blueprint. If you follow it, you can have your children back. That's all I want to do, is give you your children back. Again, the plan will suggest all the services that you do. And again, we do not want to keep your children in the system. So please cooperate with the department, cooperate with the worker, and complete your services. You will return to court thereafter for status on your matter. If you are cooperating and you're completing your services, you might ask the judge to grant you additional visitation, maybe unsupervised. Everybody gets supervised visitation initially. Maybe you're cooperating, maybe you're completing your services and you want more visitation. So you might ask the judge for unsupervised visitation. You might ask the judge for supervised overnight visits and unsupervised overnight visits. Say your parents or your mother, the grandparent is keeping the child, and you want to spend the night with the baby in grandmother's house. That's an option that you can ask for if you are cooperating and you're trying to correct the conditions that caused your child to be brought into care. The next step in the process is the adjudication or the trial. At that time, the court will determine whether the child was abused or neglected. The court will hear testimony about the alleged abuse or neglect. The worker from the department will testify, a doctor might testify, a police officer might testify. If the court determines that there was abuse or neglect, we will then move to the next phase called the disposition, At that point, the court will determine whether the minor should be adjudged a ward of the court and whether the parents are fit, willing, and able to take care of the children, or whether they are unable to do so, and that you will still require some assistance from the department. They will also determine whether the department made reasonable efforts to help prevent or eliminate the need for removal of the children from the home. At that point, one of a few things could happen. The case could be dismissed. Rare that it happens at that point, but the case could be dismissed. The children could be returned and the case is closed. Or the state, and in most cases, the state will be named the guardian of the minor, and they could be returned to the parent under an order of protection. The order of protection might say nobody can visit the kids but the mom, or there are many things depending on why the case came in. Or the state will be named the guardian and the children stay in the system and we continue to work on correcting the conditions. The parents have a right to appeal that decision. If we name your children, name your children wards of the court, you do have a right to appeal that decision. Of course, that's to be done within 30 days. If you want to appeal, we'll provide you with an attorney, will provide you with a copy of the transcript of the proceedings and assistance with appealing that decision. After that, we go into what we call a permanency hearing. Permanency hearings are held approximately every 6 months. We check on the status, we make sure you're doing your services, and then we enter a goal. It could be a goal, return home 12 months. It could be a goal of guardianship. It could be a goal of substitute care pending court determination on termination of parental rights. If that's your goal, that means you haven't done anything. And it's not fair to keep your children in a system and you're about to risk having your rights terminated. It could also be independence. If the minor is old enough, and I think the age is, 14, 15, 16, we can enter a goal of independence. That means we'll start preparing that child for independent living. He can be placed in an independent living environment. If you fail, again, to correct the conditions that cause your child to be brought into care, the state will then file a petition to terminate your parental rights, alleging that, amongst other things, you have abandoned your child, You have failed to maintain a reasonable degree of interest, concern, or responsibility as to his or her welfare. You have failed to make reasonable efforts to correct the conditions or reasonable progress towards the return of the child to you. And you have shown an intent to forego your parental rights by a failure to visit, communicate with, maintain contact, or plan for the future of the child. If those allegations are proven, we then determine whether it's in the best interest of the child to terminate the parent's rights. At that point, we look at all of what services the parents have completed, how long they have or have not been cooperating, how long the child has been in the system, if the needs of the child are being met in the home of the foster parent, if the child has bonded to the foster parent, as well as the foster parent's extended family and community in which they live, and whether the child wants to be adopted and the foster parents wish to adopt. Those are some of the factors that we look at. If the rights are terminated, we then enter a goal of adoption. The parents, again, have a right to appeal the termination order as well. Hopefully, we don't have to terminate your rights, and you will have corrected the conditions that caused your children to be brought into care. We'll be able to return the children to you. And once we return the children to you, we keep the case open for maybe 3 more months to monitor and make sure everything is okay. And at the end of the 3 months, we'll close out your case. That is our ultimate goal, is to return your children safely to you.
Thank you, Judge Buford. We have a few questions. So assuming that the goal is return home, how long does a case stay in your courtroom?
Well, it can stay for quite a while. This is a problem. If the department, I'm not gonna put all the blame on the department. It's the department and it's the parent that can slow down a case. It can take a couple of years because either the department does not have service providers, or the parents, in all likelihood, the parents are not cooperating. They're not doing their services. They send them to this service and they have to re-refer, or the service provider could have a waiting list and the parent can't get the services right away. If that happens, parent needs to call their attorney. They'll come into court, they'll complain, we'll enter an order telling the department that they have to start those services immediately. It can take a while, and it's the parents and the department who could slow the process.
So if a child is removed from the home and one parent is in jail, do they have a right, or are they entitled to visitation? Is one of the questions we have from our audience.
Every day. When we were,
I am so sorry about that.
okay. When we were in the building, we had parents coming from 26 in California. We had parents coming from the Illinois Department of Correction all over the state. They come to court. We're Zooming, they can come to court. They have a right to be there just like everybody else. Can they have visitation? Yes. However, say you have a 2-month-old infant and the parent is incarcerated downstate. Is it in the best interest of that child to carry him downstate at 2 months old to see his father behind bars? I don't know. We consult with the professionals, with clinicians. I tell people all the time, I'm not a doctor. I don't know if that's in the child's best interest, but do they have a right to see? Yes. If they're here and they want to see, yes. They see them all the time.
All right. Does child support handle child support issues?
Child support, we do not handle child support issues in our court, not at all. We don't order child support, nothing. We don't do any of that.
And can a parent sign over their rights to a relative?
A parent can give someone else guardianship of the minor, but generally that happens before they come into court. If someone else is the guardian, we're not taking the children. But a parent can voluntarily terminate their own rights. They can voluntarily surrender their rights to, say, their sister. They want the sister to adopt. We have to make sure that the parent understands that they're, giving up all their rights to the child. If we think that there's an issue, we have a clinic in the building. We have psychologists in the building. If I think that this parent is really not sure that they want to give up their rights, we'll send them up to be evaluated by one of the clinicians in our building.
So another question is, if the children are removed from the parents, do the parents have any input as to where they're placed within DCFS?
Yes. as I said, the first place we want to place them is with a family member. And that's the first question they'll ask you when they take the kids out of your home is, do you have a relative that you would like your children to stay with? Now, they have to go back and check out the relative and make sure they don't have any complaints.
What if it's not a relative? What if it's a friend?
It can be a friend. It can be a friend.
Okay. If they have one kid and that kid is a ward of the court and then the parent has another one, does the new child automatically go into custody with the Department of Child and Family Services?
Shouldn't be automatic, but it would depend on why the first child is in the system. If the first child is in the system for some serious abuse, alleged abuse, they're going to take the second child. But you go through the same process again. So you would have to come into court and the state would have to prove the allegations.
Okay. So you mentioned earlier that there was a plan that gets put in place. One of the questions I have is there a set timetable on the plan far as visitation, supervised visitation, and return home?
There is a separate, there's a separate visitation order. And the order will say that the parents are entitled to supervised visits. Again, you'll go to mediation and they might work out 2 days a week, 1 day a week, 3 days a week, whatever you work out in mediation. The judge is not going to go through all of that because it's too much. That's why we have the mediators. But they will set that out. The plan, though, the important part of the plan is that it will lay out the services that you have to do. It will say you need to do these 5 services. And it's very important that you do those. If you don't, you're going to risk having your rights terminated.
Thank you. Thank you. That was very informative and very helpful. Now we have Judge Jones. Judge Jones sits in juvenile court. Judge Jones, can you tell us a little bit about yourself? Tell us how long you've been a judge, your courtroom, what's your courtroom like, and just give us an overview of the juvenile justice system.
All right. Good evening. Thank you, Judge Henry, and thank you, President Judge Coleman, and it's good to see you, past President Judge Buford. Thank the Pan-Hellenic Council of Chicago for hosting this, and thank everyone who's here. And I'm so happy to be here to be able to tell you a little bit about the juvenile court and of course answer any questions you may have. My name is Judge Daryl Jones. Now I've been a judge for a little over 5 years. I'm from Chicago, raised in Chicago all my life. Went to Chicago Public Schools. After school, went to the United States Marine Corps. Then from there to law school and straight into the state's attorney's office here in Cook County. I was there for about 6.5 years. A good portion of that time was in the juvenile court, which is where I first got familiar with the juvenile court. After I left the state's attorney's office, I spent some time in the Illinois Department of Corrections as an attorney there, then on the Illinois Prison Review Board before I took the bench. And within three months of being on the bench, I was assigned to the juvenile court. And I've been in my current courtroom assignment for about 4 years, a little over 4 years in my courtroom assignment. One of the unique things about first of all, I'm going to walk you through the process of arrest and through the court process in the juvenile court. Just so everyone understands, we call our cases juvenile justice cases or juvenile delinquency cases. And they are what people would usually consider what would be criminal cases for adults. They're juvenile cases for minors, and juveniles can be accused of everything or anything that an adult could be accused of, anything from as low as theft all the way up to first-degree murder. And all those things, all those offenses I see in my courtroom. I guess probably one of the unique things about the juvenile court that's different from the adult court that a lot of people don't know is when you're in adult court, your judge is randomly assigned at the adult court. So you don't know who your judge will be. But in the juvenile court, it's based on your geographical area. So every judge in the juvenile court, including myself, we have there's a map of the county, and we know our area. So for instance, my area, my geographical area is the North Lawndale community, which is the 11th Police District. It's very, very busy. I think I'm the second busiest courtroom on the juvenile justice side. But that means with some exceptions, but the vast majority of any juveniles that are arrested from the North Lawndale area, they will come to my courtroom. The way the process starts is usually through with an arrest. The Chicago Police Department, they have a point system which they determine, and it's based on the juvenile's background, of course, as well as the nature of the allegation. They determine when that minor will go to court. Some minors are referred to court, they're held in custody and they come to court right away. Other minors, they have what we call a 3-week referral. So they'll be allowed to go home while they're at the police station. They and their parents will sign a statement, letting them know that they were notified about their court date. And usually about 3 weeks later, they'll show up in my courtroom. With some exceptions, sometimes it takes longer. And so they'll come 3 weeks and then they'll get a second 3-week period. But once they're there, the first thing we have, the first step of our process is the arraignment process. And that's when as the judge, I'm letting them know the allegations that were filed against them, letting them know there was a petition filed. And I go through every offense that they're alleged to have occurred. Being that they're juveniles, particularly in my courtroom, I make sure everything is very thorough and make sure they understand in detail everything that's alleged. They understand all of their rights, that they have the right to an attorney, and they understand if they're found to be delinquent, all of the consequences. I explained it to them there. A juvenile cannot receive more consequences than an adult would for the same offense. With one exception, the ultimate consequence for any juvenile offenders is a commitment to their 21 years old. After 21, the court loses jurisdiction. The one exception is what we call extended juvenile jurisdiction. And that's a process of where the judge can sentence the minor to up to 21 and as a juvenile, and then give him adult sentence as well that stayed. And if that minor does not successfully complete the juvenile portion, the state can move to have the adult sentence lifted. Then that minor would be required to serve the adult sentence in addition to the juvenile sentence. All right, so after the arraignment process, or during the arraignment process, we have the portion that's called urgent and immediate necessity, and that's by statute, urgent and immediate necessity. Unlike adult court, for juveniles, there's no bonds, so we don't say you have a $5,000 bond or anything like that. For juveniles, we're just looking at the nature of the offense. We're looking at their background to determine whether or not they should be held in custody or if any other restrictions should be put in place. Before we do that, we always make sure we make a finding of probable cause or hear whether there is probable cause to believe that offense was committed. What happens there, again, unlike the adult court, we usually don't have an officer come in. They can do that, but it's my experience that it's very rare to see. Actually, I've never seen an officer come to court on the probable cause portion. But what would happen is the state's attorney first would be able to, based on police documents or the paperwork they may have or statements they may have, they'll let me know what they would be able to show, what the evidence would show, what testimony would be. After the state has given me their case at that point, then the defense attorney or the minor respondent's attorney would be given the same opportunity to let me know if they believe a finding of probable cause should not be found. After I hear both sides, and I'll make a decision whether or not probable cause is found. As far as urgent immediate necessity, once we go to that stage, I'll listen to the background of the minor, if he has any other delinquency cases, if he's what they're doing in school. I hear from the parents. I always am hopeful that the parents will come to court, and I try to get from the parents, find out what's going on with what the minor has been doing at home. And then if there are any mentors, anything else that they may have, I try to get input from them before I make my decision. Of course, the point for juveniles is not to have them held in custody if it's at all possible. We're really looking by law for the least restrictive way to hold them. So it's not the first choice to say they should be held in custody. But if I believe that it's necessary based on urgent need necessity, when I hear the background of the minor, if I hear the alleged offense, then I can make that decision. Of course, that's the most restrictive thing I can do at that point, is to hold them in custody at the Juvenile Temporary Detention Center. One step down from there would be electronic monitoring, which is an ankle bracelet. Now they're GPS, so anywhere they go, it'll be able to track them. And so I can place them on that and admonish them as far as what the rules are on that, let them know if there are some exceptions where they're allowed to go, and let them know the consequences if they don't follow that. I can place them on what we call home confinement, which is very similar to electronic monitoring, but there's no actual monitor. So there's some trust that's given to the minor and to the family to make sure that they're compliant, even though we don't have the device to verify it. But with that, of course, I can give them some extra movement with other positive activities that they can do, or a curfew. And the curfew from the court can be more restrictive than the city ordinance curfew. And then if there are any other unique things, or other services that I might believe that they need, I can put that in place. We do have available to us what we call the expedited unit, which is a team of probation officers that can also monitor the minor pre-trial. And so when I believe it's appropriate, then I also will do that. If a minor demands trial, everything needs to happen quickly in the juvenile court. So if a demand for trial is made, particularly if the minor is in custody, that trial has to occur within 30 days, which is very fast, when the same exact type of case could take years in the adult court when you just go through the regular process. Although it has to happen even in adult court faster if there's a demand made. But that's 30 days. And a lot of people are not aware of that. Of course, if there's an agreement made between the attorneys, then that time can be extended. And that includes if the minor is in custody. From after that point, we monitor the case. We go through the discovery process. So the attorneys are basically exchanging documents to make sure both sides have everything that they need in preparation for a trial or negotiated plea. A lot of times we'll have status updates, usually within 30 days, every 30 days or so. Depending on how I feel, I make the decision. I could have it more often. So for instance, if there's a minor that I'm, for whatever reason, if I'm concerned about, I may have that minor come in as soon as the next week, particularly now that we have Zoom, to get an update, to find out what's going on, or if there's a particular issue. Say, for instance, I want to make sure the minor is in school, because I find out some minors haven't been in school for years, which is hard to believe. But if I want to make sure they're enrolled, I may keep that on a shorter schedule. I may say I need to get an update in 1 week. But on average, it's about every 30 days or so, we'll get an update to see where the attorneys are with the discovery process. Most cases are negotiated. So there's a plea. And so the minor will, after discussing it with the minor and the family, they will admit that the state could prove what they're alleged to have done. They would admit that they did it, and they plead guilty in court. And we have that hearing. There are other cases, of course, where there are no agreements, and the parties want a trial. And in that case, the trial is handled pretty much the same way as any other trials you may have seen in the adult courts. That's the same way. And even now with COVID, of course, with the restrictions that have been made, we do have in-person trials at the juvenile court in my courtroom. And it's the same. I don't think I need to explain that process, because it's the same type of trial that you all have seen, where the state presents its case, calls its witnesses. The minor's attorney will be given an opportunity to cross-examine the witnesses and also ultimately put on their own case. If there are any pre-trial motions, we handle those. Ultimately, I'm the trier of fact as judge, and I weigh all the evidence and I make the decision whether or not I believe that the minor is guilty or not, and I make that finding. If the minor is guilty, we set the case for disposition, which is our sentencing. Between the time of the finding of guilty and the sentencing, every court date, I make a new finding of urgent immediate necessity and make sure the appropriate restriction is in place. Before the disposition, the probation department would need to prepare a social investigation, and that's a report that's made when the probation officer speaks with people important to the minor, speaking with the minor themselves, speaks with the family, mother, father, siblings, look through reports and let me know the background of the report, why the offense occurred, if they can get that information from the minor. Basically, all these type of details is provided in that social investigation. In addition, a risk assessment, what we call a JRA risk assessment, is put together, and this is assessment by the professionals to tell me what they believe the risk factors are for the minor. We have what we call a GSST report, and this essentially is a report of social media. We have people in probation that are specially trained to go through all the social media accounts of the minor. They don't have to be friends with the minor or follow the minor. They're able to go in and get photos and things like that and posts of the minor that's provided to me for sentencing. And that's important because sometimes I may see a minor that will come to court, or even a family that comes to court and they present themselves in one way. And then I get that social investigation and I see the pictures of the minor, and it shows a totally different picture. I've seen that too many times to count how many times I've seen that. So all these things are provided to me for disposition. At that point, the state will have an opportunity to let me know what they believe the sentence should be. The minors will have that same opportunity. I'll hear again from the family, from the attorney, from the probation officers, and ultimately I'll make a decision. At disposition, by law, we are to look at the least restrictive alternative, and that's been in place by law. And that's something that I don't think is reported a lot, and I think it's something that a lot of people don't understand. But by law, it states because a lot of people think the first thing you do is send them to the Department of Juvenile Justice, but the law states that you have to look at the least restrictive alternative. And not only that, you have to list on the record why the least alternative didn't work, why other things didn't work. So a judge can't just say the words and just say, this is the least restrictive alternative. That's not enough. You actually have to say, we made reasonable efforts, and say what you tried to do and why those things did not work before you can sentence a minor to the Department of Juvenile Justice. If a judge does not do that, the minors can and have appealed, and that decision can and will be reversed. And so it's very important that the judges follow the law. And so you look at you consider the minor's background at the sentencing, and then you determine what the sentence should be. A lot of times, vast majority of times, particularly the minors have no background, they'll be placed on a term of probation. And it could be probation or intensive probation. Right now, we're going through a transition, and intensive probation will no longer be something we can do. We're now going into a reporting center, and there's going to be a range of services available at the reporting center. That just got started. This is like within the last month, but that will take the place of intensive probation. But ultimately, that's the decision. Probation, if the minor has an extensive background, or I believe it's necessary, then of course a commitment to the Illinois Department of Juvenile Justice. After a sentence has been given, the minor I have to inform them of their appeal rights, and so they have the right to appeal. And then from there, we have occasional progress reports. And again, those are just based on how long I believe will be appropriate. So again, some minors, if I'm particularly concerned, I may have their progress reports more frequent because I want to see what's going on with them. Other ones, if I'm less concerned, I may set the progress report 3 months or even further. Some it's rare, but it does happen where there's someone and I'm very confident that I'm not going to see them in a negative way again. And those unique cases, I can actually set the case for termination right from the very beginning. And which basically means the probation officer is going to monitor it, but they don't need to come back to court unless there's a problem. The probation officer and attorneys can put that case on the call. And then lastly, I would say, because Judge Buford went over the process on the abuse and neglect side, there are some unique situations where even though a minor, we have a lot of minors that are duly involved, which means they're involved in both the child protection side and on the juvenile justice side. But there are situations where the juvenile court judge, like the juvenile justice judge, like myself, can actually start a process of making an abuse finding and then actually start the DCFS case on our side of the building. So that it's not very common, but it's not uncommon. So it happens a fair number of times, although it's not a daily occurrence, but that is something that's possible. So that's basically the juvenile justice side. We try to make it non-adversarial. We're really looking at the principles of restorative justice, but that's basically what it is. And the whole goal is to try to turn the minors around. And I always say I've seen a lot of tragedies, and it's so easy to focus on the tragedies, but at the same time, I've seen a lot of success stories. And those are the ones I like to see when the system actually works and the minor is turned around. And it's amazing when you see that.
Thank you, Judge Jones. We have a few questions. The first question was, who and how do they decide if a juvenile is charged as an adult?
So a lot of it's based on the way it's based on the law, and it's also based on the state's attorney's office, and then of course the judge. If a minor is 16 or 17 years old, there's three offenses that are basically they used to be called automatic transfer. They're excluded jurisdiction. And so those offenses are first-degree murder, aggravated criminal sexual assault, and aggravated battery with a firearm. So basically, if a 16 or 17-year-old murders someone, that case is going to get transferred directly to the adult court. Aggravated criminal sexual assault is basically what people commonly refer to as a rape, but there's something that's done to aggravate it. For instance, there could be a rape and they use a weapon, or a rape to someone who's disabled or senior citizen or someone who's underage. Those are, the statute lists a number of factors, but those will make it aggravated. And if they're 16 or 17 and they're accused of done it, they're automatically are going to get transferred. Aggravated battery with a firearm, if they personally discharge the weapon, they're 16 or 17, they shoot someone, and it's aggravated, like cause great bodily harm or any other aggravating factors in the statute, then that minor will get automatically transferred. You have other instances where the state can request a discretionary transfer. Then the statute sets a list of factors that a judge can consider. And I'll just say that those would not come to my courtroom. There's a specific judge, Judge Bowden, who's been assigned that duty. But any type of discretionary transfer or extended juvenile jurisdiction cases that's requested, they will go to his courtroom. But basically, that's what he has to do. He has to follow the statute. First of all, the state has to bring the request, and then they have to prove all of the different elements in the statute. And then the Judge Bowden, has to weigh those factors. And if it's discretionary, he makes that determination whether or not they're going to get transferred to the adult court. If they do, of course, he does that transfer. If they do not, then he will transfer the case back to the judge in the geographical calendar, whichever assignment that might be.
Thank you for that very informative information. For those of you who are joining us, please remember, if you have questions, please put them in the chat. Our judges are here to answer any and all questions that they can. The next question I have is, can a juvenile ask for a jury trial?
Well, there are three Uh, the answer is no, they can't. Well, generally, no. For most offenses, a juvenile would not get a jury trial. They'll get a bench trial. There are three exceptions. One is called a habitual juvenile offender. And this is basically, this is all laid out in statute by law. But the habitual, this is basically where someone has committed different offenses repeatedly in an order that's set out in the statute. And if they qualify for that, then they do have the right to, the state has to give a particular notice and request. But then at that point, that minor would have the right to request a jury trial. The second way is called a violent juvenile offender, and it's very similar as habitual, but these offenses, they're offenses for violence, and it has to be multiple instances, and it's set by statute. But if the state gives that notice and this minor qualifies, then that minor can request. And the last one is what I mentioned earlier, extended juvenile jurisdiction. And that's the instances where the state requests it and the judge grants, where the minor can have a juvenile sentence up until 21 and then an adult sentence. If that's granted, then that juvenile will have the right to have a jury trial. So besides those three instances, there are no other opportunities for juveniles to have jury trials.
All right, so we're getting a number of questions. One question that we have is, who represents the minor in juvenile court?
Well, the minor has a right to an attorney. So by law, if they don't have an attorney, a public defender, an attorney from the law office of Cook County Public Defender would be appointed. There are other times where the minors will have private attorneys, and they can have one from the very start, or what's I would say probably more common is they may start with a public defender, and then as we're going through the discovery process, at some point I'll be informed that they're trying to transfer over to a private attorney. Then that private attorney will make their appearance. I'll give them leave to file their appearance, and then that case will get transferred to that private attorney. But the minor is always represented.
And you mentioned a minor. What is the age bracket? What is considered a minor? What age is considered a minor?
Anyone that's 17 and under is a minor. Okay. By law. I would say of course, the typical ages that we see in the juvenile court would be between 14 and 17 or 18. Those are probably the vast majority of them. But then we do see some in the lower ages, 13 and even younger.
All right. So what is the advantage and disadvantage to having the juvenile cases assigned geographically?
Well, it gives you because you want to give more attention to juvenile cases, and it gives you an opportunity to establish a rapport with the minor, with the family, with the community. Being that and that's really good, because I've gotten minors and I've gotten other members of their family. I can't tell you how often that happens. And I know even before anyone says anything, I already know based on what I'm hearing that this is the person's brother. Now, you don't use anything like that when it comes down to the offense. But when I'm looking at urgent immediate necessity, we're trying to do what's best for the minor. And so it's best for the judge to know as much as possible about what's going on, and then you can make the best decision. So it's really good as far as establishing a rapport with the minor, with the family, and with the community.
Okay.
To understand the areas that the minors are in, just to know more details about every aspect of the minor's life. Because when you're wondering what's going on, you want to look at everyone that's surrounding the minor and the environment, and it's really good to understand all of that.
So another question that was put in the chat was, so if you have a 14-year-old who commits a violent crime and you sentence them to detention, how long can they stay there? What's the maximum amount of time that you can place them in custody?
All right, so if a minor comes in, and at arraignment is a serious offense, most offenses, if there's a demand for trial, the limit to be held in custody will be 30 days. That's by statute. There are some exceptions, of course, murder there's an extended time period that can be requested. But for most, the vast majority of offenses, it's 30 days if the minor's attorney is also answering ready and demanding trial. What will happen most of the time is there'll be an agreement, and so you can hold them longer because the attorneys, even the minor's attorney, is not ready for trial yet. And so for those instances, it can go on longer as appropriate. And then, okay, so that's up into trial. If they're found guilty, of course, if it's appropriate, they can be sentenced to Illinois Department of Juvenile Justice. But as far as a sentence to the detention center, there can be a 30-day sentence as well.
All right, so I have just a few more questions that are coming through the chat. You mentioned that a minor gets appointed a public defender if there is no private attorney hired. At what point does the minor get appointed this public defender? Assistant public defender.
At arraignment. At the arraignment. So the very first day I see the minor, he or she gets appointed an attorney. And
this question is for Judge Buford. What are the options available to the court if the Department of Children and Family Services is unable to locate a service provider for the family, or there is a long wait list?
You're on mute, Judge Buford.
You order the department to find a service provider. If there are tons of service providers, we're in Chicago, there are tons of service providers. You find one where I order routinely say, no wait list. Start this service in 14 days, no wait list. That's on you, department. You go out and find a service provider. This is a large metropolitan area. There are tons of service providers. Find one.
All right. So the next question that came for you, Judge Buford, is if a child is abused in the custody of one parent, does the other parent automatically have to complete services to get custody of that child?
No, I have had many cases where the mother has custody, the child is allegedly abused and with the mother. Father comes in, he doesn't live in a home, he had nothing to do with it. He's a wonderful person. He will be assessed, but I always tell them, do not, offer him all these services that are unnecessary. He had nothing to do with the reason why the case came in. He's got a job, he's a working man, he can take care of this child. Yes, he can have his baby.
Okay. Another question that came in, you mentioned earlier about locating the father. What happens when you don't even have the name of the father? What do you do?
We publish to unknown and all whom it may concern.
Okay. And Judge Jones, this question is for you. What % of the cases before you would you say the minors are represented by attorneys from the public defender's office?
Probably 95%. It's the vast majority of cases. Might be more than that, but the vast majority are represented by a public defender.
And on average, how long would you say a case remains in your courtroom?
They're definitely not as long as Judge Buford cases, as the abuse and neglect cases. That can vary. If I would say my average term of probation is usually between 2 and 3 years if the minor is found guilty and placed on probation. It could be as low as 1.5 years, and it could be up to 3 years. That being said, if a minor is doing really well, I always let them know they can request an early termination. So even if I place a minor on 3 years of probation, they don't necessarily have to stay in the system for 3 years, particularly if they're doing well. They say they graduate, they're getting a job, they're staying out of trouble, no other cases. I always talk about resources. I'd rather the resources be used for someone who needs them, which we have plenty of people who need them, rather than have them with someone who's doing really well. And we try to expedite all the cases. So I would probably say on average, by the time we get to adjudication, and of course, COVID kind of extended things, but I would say ideally it's probably within 4, 5, 6 months that we'll get the case to adjudication. Sometimes a lot quicker. Unfortunately, sometimes it could be longer, particularly for serious cases.
All right, Judge Buford, there was a question that came in for you. It's two, actually. What is the advantage for the parent to seeking out their own services?
A parent can do that, and actually I look favorably upon a parent who does that, but that provider has to be approved by the department, because we have to make sure that, for instance, they go out and find their own therapist. We have to make sure that the therapist is addressing the goals that the department has set. So I look favorably if you do that, but you have to make sure that it's an approved provider.
And who represents the parent if they can't afford an attorney?
All, like Judge Jones said, 95, 98% of our parents are represented by either the Office of the Public Defender, or we have a list of bar attorneys, and they're paid by the state. So if the Public Defender's Office, and then they have the conflicts unit of the Public Defender's Office, and then we have bar attorneys, and they're all free. Okay. Everybody has representation.
This question is for both of Judge Buford and Judge Jones. So we know that we have moved to a hybrid where we use Zoom. What does a parent do when they don't have access to a computer or a phone, but they need to appear in court?
Well, and on our side of the building, juvenile court is one building. Abuse and neglect is one side, juvenile justice, Judge Jones, they're the other side. On our side of the building, we have rooms set up outside of each courtroom where there's a computer. The sheriffs are trained to bring the parent in, sit them at the computer, and put them on Zoom. If the parent, through their attorney, of course, wants an in-person trial, they can have it. We come in, we do the trial in person, but we have it set up in the building.
Judge Jones?
Right. And I also want to make sure I correct my previous answer about the public defender. For my area of juvenile court, we do have an agency called we call them LCLC, Lawndale Christian Legal Center is what it is, Lawndale Christian Legal Center. And they do represent minors. And so I can't put it into percentage, but I would say between the public defenders and Lawndale Christian Legal Center, that would make the 95%. The other 5%, I was thinking those are private attorneys, but that would be I guess a more of a percentage that technically are represented by private attorneys, but they're through the Lawndale Christian Legal Center. As far as if the minor or the family, if they don't have a phone, they're required to be in contact. So if they don't have a phone, we have a setup at the courthouse, then they're required to come to the courthouse, and we have a Zoom room set up right outside the courtroom where they're able to make appearance. I would say that has not been for the juvenile court. That has not been my experience, that people don't have access to phone. Most of them, well, everyone has had access that I've seen. A lot of times, the ones that will come to court, with the only exception of one that I can think of, most of them prefer to come to court, even though they have the option to do Zoom remotely. They prefer to come to court.
You know, that's really funny, because on our side, it's quite the opposite. First off, nobody uses the setup Zoom rooms. Everybody has at least a phone. They have access to computers and phones. The children have computers in the house, so they have access. But they all love Zoom. It's been a wonderful tool for us because parents can participate in the hearings. They don't have to drive into to our building, pay for parking, now pay for gas. They can be at home. They can be with the children if they have other children. They can be at work in a conference room. They don't have to miss a half a day at work. Our parents love Zoom, and we get great participation. In fact, the PDs were saying just the other day, they usually ask to be vacated because parents are not cooperating and they can't get in touch with them. Now they say they have all these cases because all the parents are cooperating. It's a wonderful thing for us.
Okay, so we have another question. How can the public observe juvenile court and child protection court? And is there Zoom information?
You can't observe child protection court. It's totally private. Nobody can come in but the family involved. And oftentimes they may even excuse some of those people. It's can't come in by statute. It's not public. I don't know about the other side.
It's just the same thing for the juvenile justice side. It's they're confidential proceedings, so just members of public aren't allowed in. There are exceptions for like media. So some of the cases that you may see in a newspaper, we may have a media representative there, but they have to get approval from the presiding judge. And everyone who, regardless of who they are, if they, including staff people that may come in to observe, they have to accept that they're confidential proceedings and they're not able to communicate the minors' names and things like that.
All right. What are the expectations that you have of litigants when they appear in your courtroom on Zoom?
Basically what you said, it's a courtroom, it's professional, keep your clothes on, don't lay in the bed, you can't have other people in the room. Again, like Judge Jones says, it's confidential. We can't have people running around in your background. We have to identify everybody that's on the record. We have to identify everybody. And if you're in the room with somebody else, we have to ask them to leave. And it's a courtroom. Just be professional. Act as if you're actually in front of the judge in court.
Judge Jones?
That's exactly the same. I try to run an open courtroom, and I particularly with the minors, I want to hear everyone who's around them. So if there's anyone in the room, as Judge Buford said, I have to have them say their names on the record. And if they're in the courtroom, they're there for a reason. So I would like to get input if someone has anything to let me know about the minor, or I need to know why they're there. I do have to remind people, what I tell them is, if you would not do it in the physical courtroom, then don't do it on Zoom when you're there. So if you're, there's no eating. I mean, these are things I've seen, no eating. I've seen people think they can come with no shirt on. Of course, that's not permitted. No smoking and, things like that. And so I just remind them, if they wouldn't do it in the courtroom, don't do it on Zoom.
So what advice would you give for someone who misses court? What should they do?
Well, for juveniles, these are serious cases. And so if they miss court, there really needs to be a good reason. They need to be in contact with their attorney or the probation officer ASAP, because we assess the situation. But if a person is not there and we're concerned, I do issue warrants. And so that we really want to avoid doing that if we don't have to. So the first thing they should do is get in contact with their attorney or probation officer or someone in court.
Judge Buford?
It's not mandatory for us that the parents be in court. In fact, I might say, I don't want you to lose your job. So you don't have to come to court. They have representation. They have they have their attorney there. They don't have to physically be in court. Of course, it looks good if you're there all the time and you're showing an interest in your case, but I don't want you to lose your job running to court every couple of months. So they don't have to be in court on our side. They have representation.
Okay, so suppose the minor is unhappy with his representation, Judge Jones, what steps or what can he do because he feels like he's not getting the representation he needs? And it's a public defender.
Right. So that would be something they can address with the supervisor, kind of chain of command through the public defender's office. But it's not a situation where I, as a judge, will start picking the different public defenders within the office that would represent them. That I cannot do that. But it happens from time to time. And of course, we try to resolve it. And I try to run an open courtroom and try to be non-adversarial. So if there's anything that could be addressed the easy way, then we address it. But it hasn't happened very often, but it has happened. But they would address it with maybe with the supervisor at the public defender's office and figure out how to resolve it if there's anything else they can do. Or, of course, they could have the option of getting their private attorney.
Judge Buford?
Happens all the time on our side. They're just not happy with their attorney. We often give them another attorney. We'll give them, we'll try another attorney from the PD's office. Sometimes they'll say, we don't want to do it. They don't want one attorney, we're not going to do it. We'll give them a bar attorney. We may give them another bar attorney, but after the second or third time, that's it. Either you're going to do with it or you're going to have your own attorney, or we'll give you an attorney on standby. We'll give you a bar attorney on standby, but we can't keep changing it because you're delaying the case. And they can't afford a private attorney. It's just not going to happen.
All right, so another question we have. So I have court with you, Judge Buford, but I don't have my Zoom information. Is there a website or location where I can go and get the Zoom information?
You get it from the worker, you get it from your attorney.
All right, so it's not on any website.
Because it's confidential proceedings. It's not going to be public where people can, not only that, but even if you were to get into the room, you're going to be on a waiting room. You're not going to be let into the courtroom at all. Nobody comes into that courtroom.
Okay. Are there any community organizations that provide free legal services for juveniles or their parents, Judge Jones?
I believe it's Cabrini Green Legal that has a clinic in the courthouse, particularly for expungements. Then the Hondo Christian Legal Center, as I mentioned, they're very, very active, and they give a lot of legal advice and legal services for minors. For my geographical area, those are the two main ones that I hear mostly about. But that might be different depending on, as I mentioned, different geographical areas. So you may speak to another juvenile court judge that might have a particular agency that works in their courtroom.
What percentage, Judge Jones, of your cases are trials, and what percentage would you say are plea agreements?
The vast majority are plea agreements. Trials, if I were to guess percentage, maybe 10%, and it varies. Like as many things pick up. So, for instance, now I have a number of trials that are set. Like now we're setting trials for May. If you request a trial today, the earliest you'll get on the trial call is probably going to be around early May, because we have numerous trials lined up. But it's not always like that. But for whatever reason, right now we're getting a time period where it's really picking up. Summer, and this is before summer, a lot of times pick up in summer. So it may really be busy this year. But I would say probably on average, my just from the top of my head, I would say maybe 10% are trials and the 90% are pleas.
All right, Judge Buford, how about you?
Everything goes to trial. But another reason why he just reminded me, it takes so long as our calendars are chock full. So it may not, like right now, if you're in court today, you probably won't get a trial date until, I think we're up to maybe August or September right now, September, October maybe, before you can get a trial. That's another reason it takes so long. We have a lot of cases.
All right.
But everything goes to trial. We have, in our system, we have two trials, the adjudication and the termination trial. So everything goes to trial.
Well, do we have any more questions for our lovely panelists? They have been a wealth of information. We hope that you take the information that you have heard from our panelists today and that you share with your family and friends. And we hope that you also share with them that we have one more session coming up. Next week will be our final session. It will cover traffic court, pretrial, and criminal law. So that will be our final session, and it will be another session of a wealth of information from your judges in the community. And at this point, I'm going to turn it over to our president, Ms. Coleman, Benita Coleman. You're on mute.
Good evening again, and I hope that you were well informed about with regard to our seminar tonight, our topics, child protection and juvenile justice. You received a wealth of information with regard to the process, a little information about the law, and also information about our legal resources. A few things that I'd like the viewers to keep in mind is what the panelists said about Zoom. It is so important that each and every individual on Zoom come prepared and be professional while in Zoom. Don't forget that you are in a court proceeding, and it is the same as if you have gone to the courthouse and appeared before that judge when you appear before that judge on Zoom. Keep in mind that you need to be ever present. The judges have made comments with regard to acceptable and unacceptable behavior. Unacceptable being lying in the bed, walking down the street when you're on Zoom. You need to be in a place where you can be ever present and also attentive as to your matter. We need to know that you treat your matter, or you believe your matter is just as important as we believe it is. If you don't treat it important, then nobody else will. So please be mindful that you need to be ever present when you are on Zoom. Keep in mind with the commonality with both of these proceedings, child protection and juvenile justice, that you have rights. You have a right to be present, you have a right to be heard, and you have a right to have representation, legal representation in all of these proceedings. So keep that in mind. Also, the judges have all provided to you some legal resources. Judge Jones talked about LCLC being an entity that represents defendants in the event that there is some conflict with the public defender's office. Also, Cabrini Green Legal Aid was placed in the chat. A link was placed to that particular organization to seek out resources for assistance. So we hope that you enjoyed the presentation this evening. Again, as Judge Henry has said, we will be back one more time next week, and you will hear information with regard to criminal law, traffic, and pretrial. So we look forward to meeting you and seeing you next week, and thank you again for joining us this evening.
Good night, everyone. We hope to see you next Wednesday.
I think everyone has been removed
I think
except
there's one more.
Maryland. I was removing them, but I can't remove Maryland.
But see, I can't remove anybody.
Oh, I was removing them, but I can't for some reason. Maryland, can you disconnect? I don't know why.
Also shows us, my screen shows it's live on YouTube also.
Oh, I'm sorry. Is it still live on YouTube?
That's what mine says, yes.
Yeah, it is. We need to take down the YouTube.